We took the child out when it was already dead. We tried to help for 30 minutes as the protocol required, but to no avail. The woman was still alive. We managed to speak with her. She did not want to be alive. She probably realized the condition she was in, but most importantly, she couldn't feel the child's movement. Therefore, she said, "Don't save me. Don't do anything. I don't want to live. I want to die." She kept repeating this. We did all we could to save her. These are the words of a doctor who treated the lady from the demonstrated photo and other pregnant women evacuated from Mariupol maternity ward, bombed by Russia. Dear ladies and gentlemen, we are having this event against the backdrop of these horrific crimes, which are being perpetrated as we speak. However, our conversation today will concern the larger enabler, the crime of aggression against Ukraine, and the ways to hold Russia accountable for it. My name is Katerina Busol. I'm an international lawyer and an academy associate here at Chatham House. And about a month ago, a group of international lawyers, politicians, and public intellectuals presented their idea of a special tribunal to hold Russia accountable for the crime of aggression. Today, with the greatly experienced colleagues, we will reflect upon the idea of that tribunal, as well as on other modalities for having Russia accountable for the crime of aggression. I'm very grateful to welcome today Professor Gnatovsky, the advisor to the Minister of Foreign Affairs of Ukraine, and also Professor of International Law at the Kyiv National Taras Shevchenko University. Dr. Kerry McDougall, who is a senior lecturer at the Melbourne Law School and who has written a lot and participated indeed in the negotiations concerning the crime of aggression within the framework of the International Criminal Court. We'll further be joined by Professor Kevin John Heller, who's a professor of international law and security at the University of Copenhagen Center for Military Studies, a professor of law at the Australian National University, and a special advisor to the prosecutor of the International Criminal Court on international criminal law discourse. Finally, we will be joined by Professor Adil Haq, who is a professor of law and Judge John O. Newman Scholar at Rutgers Law School. Dear colleagues, we are starting this discussion with the intervention from Professor Mykola Gnatovsky, whom I kindly would ask to reflect about how the idea of the tribunal has been perceived around the world, and more importantly, by the public and the survivors in Ukraine. Professor Gnatovsky, over to you, please.
Thank you very much, Katerina, and thank you very much for the invitation. I'm very grateful to Chatham House for hosting the event on the 4th of March this year, and also for organizing this follow-up event. And I'm very privileged and humbled to be in the company of brilliant international lawyers who are extremely competent in this subject and who have already published extensively on it. And all those publications have been truly helpful. Now, I will concentrate on three things. I will first speak about the origins of the idea and what makes this idea so timely and important. Secondly, I will, as indeed requested by our moderator, by Dr. Busol, to speak. I will just mention a few things about the reactions that this idea has gathered so far, and finally I will also try to say a few words about the prospects of this idea being materialized. Let me first say that the proposal to set up a tribunal for the crime of aggression against Ukraine appeared rather rapidly after the beginning of the large-scale invasion by the Russian Federation in Ukraine. So basically already in the last days of February, this idea started circulating. Perhaps one of the most clear-cut and lucid articles published on the subject immediately was an op-ed by Professor Philippe Sands in Financial Times. And essentially this idea has been picked up by Ukraine and by Ukrainian Foreign Minister Dmytro Kuleba, who also happens to be to have a background in international law and more particularly international criminal law. So he knew exactly what it is about. And then he asked me to essentially follow up on this idea, as this is the subject we worked a lot together. I've never worked for the state, and I still remain an informal advisor, a special advisor, just in these matters to the minister. The statement and the declaration that were announced here at Chatham House on the 4th of March were formulated very quickly in a matter of a couple of days, and the further steps were undertaken, including ensuring a public support to this initiative, and also trying to think again about all the legal options and subtleties that exist here. But first of all, let me make clear one thing before going into the more specific discussions that I'm sure my distinguished colleagues will be embarking on soon, is that we do not need to look into explanations why this can't be done. We need to find a way to do this. We need to find a way to do this because we are facing an unprecedented, since the Second World War, large-scale aggression by one sovereign European state against another sovereign European nation. The aggression which is accompanied by statements denying the very right of existence of the victim of aggression as an independent nation, an aggression which is accompanied also, as wars often are, with terrible war crimes and crimes against humanity, which the example of which Katerina has just given in the beginning of this webinar. So this is also an act of aggression which has been condemned by 141 states who voted in favor of the United Nations General Assembly resolution. And also there is one more consideration here that is less of a legal value, but I think more of a practical value, because an argument was raised at the beginning that why bother, Ukraine will be done in a few hours or in a few days, and then life will move on. That was the sort of the implication of these kind of conversations. It is obvious that the attempt to destroy Ukraine as an independent nation has failed. And Ukraine has been able to defend itself also with certain help from an important help from its allies, not military help though, but at least in terms of weapons and also important sanctions and other means of self-help, so to say. So this is something that Ukraine is certainly willing to pursue and will be pursuing, even though, of course, there will be a context of negotiations, there will be a context of a ceasefire, but this crime has been committed. This is a continuing crime. It continues every day with the continuation of the aggression. It is not a one-time crime, certainly. And this is a crime which is rather brazen and straightforward in terms of its legal qualification. Now, in terms of the reactions received, of course, I'm sure you're aware of the public appeal that has been made and which has gathered by today around 1.5 million signatures of various people around the globe. The initial declaration has been supported by dozens and dozens of former judges, of academics, of public figures, and the list of people who have asked to add their signatures is only growing. At the level of state reactions, there have been intensive consultations. I participated in a number of such meetings at the level of legal advisors to foreign ministries. What I can tell you, albeit these are confidential meetings, there is not a single person I met who has expressed the disagreement with the necessity to act and the necessity to set up such well, a mechanism for individual criminal responsibility for the crime of aggression. And it is not, as one, well, somebody, I think Bill Shabas wrote, it is not an ad hominem tribunal, it is an ad hoc tribunal, because it's not one person. This would be the entire leadership of the Russian Federation. This would be at least several dozen of persons. So in general, this has been a positive reaction. Of course, there are obvious legal issues that have to be addressed, and I'm sure my colleagues will be speaking about them, so I will not now embark on this discussion, but I'm very happy to join it at a later stage with questions and answers. And finally, in terms of further steps, I think there can be further steps taken now, and will certainly be taken now. They are in the making, and they pertain to the investigation of the crime of aggression. They pertain to the activities of Ukraine's Office of the General Prosecutor, together with a few states who have already been active in investigating this crime, perhaps in the form of a joint investigation team, perhaps in the form of an interim prosecutor office. And as long as the diplomatic consultations result in a solution for the exact legal basis of the tribunal, then this should finally end up in such an agreement. I remain of the view that a multinational tribunal that has been proposed at Chatham House on the 4th of March remains a viable option. I don't see where this option is worse than any of the other options proposed, and I mean here, of course, the realistic options. But certainly, I can say that both myself as a professor of international criminal law and also the Ukrainian leadership that I'm in touch with, we are all open to other options. Whatever option will work better. So we can be quite flexible here. That's why also this discussion and the subsequent discussions are so important. Thank you very much for bearing with me. I stop here, and I'm happy to participate in the discussion. Thank you.
Thank you very much, Professor Ignatowski. And now, as we are turning to our second speaker, I would like to invite our audience to submit their questions in the Q&A function, and we will address the questions as much as possible once all the participants, all the panelists have spoken. Now we're turning to Dr. Carrie McDougall, who has also listed her recommendations regarding the modalities of the possible tribunal and the possible accountability mechanism. So we would like really to hear your reflections, please, Dr. McDougall.
Well, thank you very much, Katerina. I'm incredibly grateful to Chatham House for the invitation to join this very distinguished panel and to speak about this important issue. I'd really like to start by emphasising that it is the role of a duly constituted, independent and impartial court to make determinations about guilt. And so I think in talking about these issues, it's important not to prejudge the outcome of any criminal process. But I think we can also be clear-eyed about the evidence before us. Russia, supported by Belarus, has invaded Ukraine and is using force to prevent the exercise of Ukraine's political independence and its sovereignty, with an apparent desire to seize some, if not all, of its territory, having already annexed Crimea in 2014. This is a flagrant violation of the prohibition of the use of force amounting to an act of aggression. Russia's claims to be exercising both individual and collective self-defense have no credible basis whatsoever. Alongside Iraq's 1990 annexation of Kuwait, what we're witnessing is the clearest example of a breach of the prohibition of the use of force since 1945. In my view, it's essential that those responsible are held to account. And the reality is that if the international community wants to see that happen, it will have to establish a special tribunal. Let me try and explain why. While the International Criminal Court has jurisdiction over the war crimes and crimes against humanity being committed in Ukraine, absent a Security Council referral, the court can't exercise jurisdiction over any crime of aggression involving a non-state party, such as Russia and Belarus. That's just a reflection of the unique jurisdictional regime that governs the crime, which was the price paid for securing the Permanent Fives agreement on the aggression amendments. Now, theoretically, states parties could amend the ICC's jurisdiction. And I think Adil will, in fact, talk about the possibility of amending the Rome Statute to enable the General Assembly to refer situations to the court. And I don't want to get ahead of him here, but in my view, the General Assembly just doesn't have that power under the UN Charter. It can't create criminal jurisdiction where it's lacking. That's an enforcement power exclusively enjoyed by the Security Council, a point that was made clear to me in negotiations to secure support for the General Assembly's establishment of the International, Impartial and Independent Mechanism for Syria, a mechanism that cannot conduct prosecutions. So if we're going to consider any type of amendment to the ICC's jurisdictional provisions, the better option would be to remove the restrictions that are unique to aggression. However, having been involved in crime of aggression negotiations for the better part of 20 years, I'm sober about the prospects of being able to secure support for such a proposal. And even if we could reach that sort of agreement, the amendment would need to be ratified by 7/8 of ICC states parties, a target that's so high, it's virtually unattainable. And so for a range of reasons, I think the ICC option is currently not a realistic one. Now, at least 74 states have aggression-like offences on their books, including Ukraine, Lithuania and Poland, which have announced investigations into the crime. Any domestic prosecution, though, will face a range of hurdles. First, while Ukraine clearly has territorial jurisdiction, it's not clear that other states can properly exercise jurisdiction here, as it's doubtful whether universal jurisdiction attaches to the crime of aggression. Second, the defendants who are likely to be of greatest interest to any prosecutor are likely to be able to assert immunity before a foreign domestic court. Third, a national proceeding is unlikely to be able to secure the defendant's presence. And frankly, while a trial in absentia would be possible in Ukraine, trials in absentia lack credibility. Finally, I think there are very good reasons why the crime of aggression has always been considered a crime best prosecuted on the international plane. Any domestic proceedings will struggle to escape the taint of victor's justice or victim's revenge. And domestic judges are just not experts in the law governing the use of force by states. And so this leads at least me to the conclusion that we need an ad hoc tribunal. Such a tribunal could be established in a number of different ways. Following the precedent of the extraordinary chambers in the courts of Cambodia or the special court for Sierra Leone, it could be recommended or approved by the General Assembly and created through an agreement between the Ukraine and the UN. But equally, this could be done via an agreement with the European Union or possibly the Council of Europe, as I understand Kevin will canvass. Although, unlike Kevin, I think it's essential that the ad hoc tribunal is international in nature rather than part of the Ukrainian legal system. Alternatively, an international tribunal could be established by treaty. Such a treaty could potentially be open to all interested states. Whatever model is employed, the tribunal's jurisdiction would be based on a delegation of Ukraine's territorial jurisdiction. A mechanism endorsed by the broadest possible range of states would ensure the tribunal's legitimacy and put the tribunal in the best possible position to be properly characterised as an international tribunal before which immunity would not apply. Now, endorsement by the General Assembly would arguably provide the best possible footing for this, but in my assessment, it could be very difficult to secure the necessary votes. And so while I think we should test that assumption by consulting with states, at this stage, I think the most realistic prospect is a tribunal established by agreement with the EU or by treaty, the negotiation of which would presumably be led by those Eastern European states most affected by the current crisis, but hopefully joined by a broader cross-regional group of states. In addition to solving the jurisdictional and I would argue immunity issues, an ad hoc international tribunal would help shelter Ukraine from Russian retaliation. If a partnership with the EU is relied upon, or a treaty includes at least 2 European states, it could also take advantage of the EU's joint investigative teams, mechanisms, and resources. And on the basis of my own involvement in efforts to pursue justice for those responsible for the downing of flight MH17, I'm of the view that that would be a huge advantage. The very last point I want to make is that I think it's extremely important to ensure that the Special Tribunal complements the ICC. And so I recommend that the Tribunal statute replicate the definition of aggression found in the Rome Statute, that the Tribunal's jurisdiction be limited to the crime of aggression and the situation in Ukraine, that an agreement be concluded between the ad hoc tribunal and the ICC to emphasise their joint justice project and to deal with practical matters such as the sharing of evidence and the sequencing of trials, and that renewed efforts be made to encourage all states to ratify the Rome Statute and the aggression amendments. There's of course much more I could say, but let me leave it there for now, and I look forward to exploring some of these issues further in our Q&A.
Thank you very much, Dr. McDougall, and you actually gave an introduction to our further speaker, to Professor Kevin John Heller, who will provide yet another alternative to prosecuting the crime of aggression as a part of an extraordinary chamber. Professor John Heller, over to you, please.
Thank you. I also want to thank Dr. Bissell and Chatham House and my fellow presenters, 2 of whom are old friends, and the third will hopefully become a new one. Let me briefly begin with 2 disclaimers. The first is that I'm appearing today in my personal capacity as an academic and not as a special advisor to the ICC prosecutor. And the second is that the ideas I'll present today are not simply mine alone. On the contrary, they were initially developed in collaboration with Sam Zarifi, who is the Secretary General of the International Commission of Jurists, and were later enriched by discussions with Owiso Owiso, a lecturer in public international law at the University of Groningen, who I know is out there in the virtual audience somewhere. So I want to argue today that the best solution to the problem of Russian accountability for aggression would be for the Council of Europe to help Ukraine create a hybrid tribunal within its national judicial system, a high court for aggression that would be staffed by the best judges, prosecutors, and investigators Ukraine and the Council's member states have to offer. Now, we don't view this proposal as a rejection of the special tribunal promoted by Philippe Sands, Gordon Brown, Mikolaj himself, and other luminaries. On the contrary, we see a high court for aggression as the realization of precisely the kind of tribunal that their statement and declaration call for. Indeed, our proposal stems from a central, and I certainly hope uncontroversial, premise, namely that efforts to hold Russia criminally accountable must be led by Ukraine itself, because it is Ukraine that has suffered the most and the most directly from Russia's aggression. Ukraine can obviously not prosecute Russian aggression without the international community's help, but help is the key word here. The international community needs to support Ukraine's efforts at accountability, not supplant them. Now, as I've said, we believe the best way to do that would be for the Council of Europe to help Ukraine create a new high court for aggression within its current judicial system. So there are 2 questions that require an answer and that I want to use my time answering. First, why a Ukrainian court instead of a more international special tribunal? And second, why the Council of Europe? Let me start with the first question. To begin with, we believe that a high court makes more sense from a legal perspective than a special tribunal that would be patterned on the ICTY or the ICTR. The high court we propose would be part of Ukraine's ordinary judicial system, a chamber in its higher specialized courts. So it would be unlikely, or at least less likely, to violate Article 125 of Ukraine's constitution, which prohibits the creation of extraordinary and special courts. Indeed, there's already precedent for such a single crime court, the High Anti-Corruption Court of Ukraine, which was established in 2019 and is supported by international organizations like the EU. The court even has a public council of international experts, a group of non-Ukrainian lawyers who advise the judges and have the power to reject judicial candidates. Now, to be sure, the High Anti-Corruption Court has its problems, but its creation survived constitutional challenge. So presumably the creation of a properly constituted and structured High Court for aggression could too. By contrast, a special tribunal established outside the Ukrainian judicial system would be just that, a special tribunal. Now, I don't claim to be an expert on Ukrainian constitutional law, but I know how difficult it has been for Ukraine to ratify the Rome Statute. The creation of a special tribunal would seem to raise constitutional issues that are at least as complicated as ratification, particularly concerning Article 125. So it's entirely possible that barring a constitutional amendment that might take years to adopt, Ukraine would not even be able to participate in the special tribunal, an absence that would call into question, obviously, both the tribunal's jurisdictional basis and its legitimacy. Let's leave the law aside. A high court would have at least two significant practical advantages, we believe, over a special tribunal. First, it could be created more quickly, because unlike a special tribunal, it would not have to be built from the ground up. On the contrary, it would simply be a new addition to a judicial system that already exists. Second, and perhaps more importantly, a high court for aggression would lead to far greater capacity building within Ukraine than a special tribunal. A month ago, when the statement and declaration were issued, we weren't sure that Ukraine's government would even survive the war. We now know, happily, that it will. So the best thing the international community can do now is help Ukraine rebuild and strengthen its own judicial system. Supporting the creation of a high court for aggression would do precisely that, because it would inject into Ukraine much needed funds and training and expertise, and would give Ukrainian lawyers invaluable experience regarding the investigation and prosecution of international crimes. A special tribunal created outside of Ukraine's judicial system, by contrast, would do none of those things. So that's the answer to the first question. Let me now turn to the second. Why the Council of Europe is the right partner for Ukraine, as opposed to the UN, the EU, the OSCE, or just a group of committed states. The answer turns on two interrelated concepts, legitimacy and selectivity. Simply put, although any outside support would of course be better than nothing, having the Council of Europe support Ukraine's creation of a high court for aggression would be the most legitimate and the least selective, particularly in comparison to the other options. To be sure, the possibility of a special tribunal supported by the UN pursuant to a General Assembly resolution is seductive. After all, what could be more legitimate than a tribunal created by a body that, unlike the Security Council, represents the entire international community? The Uniting for Peace option, however, assumes that the willingness of 140 plus states to condemn Russian aggression would carry over to the creation of a tribunal able to prosecute that aggression. And that's hardly a given. Asking the General Assembly to support a special tribunal could just as easily destroy the remarkable unity on Russia the international community has shown to this point. Here, I completely agree with Carrie. Her concern is a real one. Don't forget that the African Union voted in 2014 to grant immunity to heads of state and other senior officials before the African Court of Justice and Human Rights. And we certainly don't forget how widely Omar al-Bashir was able to travel even as he faced genocide charges at the ICC, including to 13 states that are members of the court and are legally obligated to cooperate with it. Would those states really be on board with a special tribunal that claimed the ability to put aside personal immunity, knowing that the next such tribunal might come for them? I'm skeptical. A treaty-based tribunal would be a much safer option. And here I think Carrie and I are also in agreement. But the legitimacy of a treaty-based tribunal would, we believe, very much depend on which states are involved in it. It would be a shame if the tribunal responsible for prosecuting Russian aggression was dominated by the same North American and Western European states that invaded Iraq, an illegal act for which no one was ever held accountable and that did not lead to calls for a special tribunal, and that are primarily responsible for the ICC not having jurisdiction over Russian aggression now. Such a tribunal, we believe, would struggle for legitimacy in the eyes of many states, particularly those in the global South. Yet, if the history of international criminal tribunals is any indication, those are precisely the states that would be the most likely to lead an ICTY-like special tribunal. There is, however, a better option, the Council of Europe. Although the Council includes some states whose hands are anything but clean in this area, there is no international organization whose membership is so overwhelmingly committed to accountability for aggression. Let me just give you a few statistics. Only 43 of the ICC's 123 member states have ratified the aggression amendments. 28 of the 43, 65%, are members of the Council of Europe. Only 39 states in the world have criminalized aggression domestically. 26 of the 39, 67%, are members of the Council. Overall, of the Council's 46 member states, 37, 80%, have either ratified the aggression amendments or domestically criminalized aggression. Because accountability for aggression is such a robust regional norm in Europe, the Council is the right organization to help Ukraine create a high court for aggression. Its members not only have the necessary credibility, they also have the necessary capacity, given that many of them, such as Germany, the Netherlands, Sweden, have vast expertise and experience investigating and prosecuting international crimes. And of course, the Council can hardly be faulted for selectively focusing on Ukraine, as it is an exclusively European organization. So to conclude, there's no question that Russian leaders must be held accountable for their aggression against Ukraine, but they must be held accountable in the right way, via a mechanism that will promote, not undermine, the long-term viability of the crime of aggression. For all the reasons I've mentioned today, the mechanism most likely to realize the goals so ably articulated by the Sands-Brown statement and declaration would in fact be a hybrid tribunal, a high court for aggression established in the Ukrainian judicial system, led by Ukrainians and supported by the Council of Europe. Thank you.
Thank you very much, Professor Haller. And now we are turning to Professor Haag to comment on a very debatable and interesting issue of the reform of the possible referrals of aggression cases within the ICC, whether in light of Russia's current aggression, this reform can indeed happen. And more importantly, if it does happen, will that concern actually Ukraine? Will Ukraine be able to benefit from the General Assembly referrals within the ICC? Over to you, please, Professor Haag.
Thank you very much, everyone. So I believe that states parties to the ICC statute should amend it to permit the court to exercise jurisdiction over the crime of aggression if the UN General Assembly, acting under the Uniting for Peace framework, refers a situation to the ICC prosecutor in which aggression appears to have been committed. This could be done by modifying Articles 13 and 15 ter of the statute, or perhaps by introducing a new article. I'm not alone in favoring this approach. Most notably, Shane Darcy published an extended argument in its favor on the Just Security blog, and I commend his essay to the audience. So Shane and I favor amending the ICC statute over creating a special tribunal for essentially two reasons. First, it is more principled. It would create a durable legal framework that could apply to Russia today, but to China or to the United States or another P5 member tomorrow. It would avoid the charge of selectivity. Its legitimacy would track that of the Uniting for Peace framework itself, which was just resoundingly reaffirmed. If the Security Council fails to exercise its primary responsibility, in this case, to determine the existence of an act of aggression, because of the abusive exercise of the veto by a permanent member, then the General Assembly must assume that responsibility within the limits of its competence, as it just did. Second, this proposal is more pragmatic. Establishing a special tribunal will consume resources, not only money, but also expert personnel, better deployed elsewhere, all for an uncertain prospect of prosecuting those political and military leaders responsible for the crime of aggression in Ukraine. In contrast, the International Criminal Court is already up and running. The upfront costs have been paid. If the proposed amendments are adopted, the GA refers the situation in Ukraine, and suspects are arrested and surrendered to the court, then prosecutions can commence with relatively modest increases in costs and staff. There are essentially two objections to this proposal. One is pragmatic, and Carrie has already foreshadowed it. Amending the Rome Statute will take time, and it may be difficult to achieve. Some states parties, perhaps the United Kingdom, might oppose such an amendment. Other states parties might be pressured by non-states parties, perhaps the United States or China, to vote against it. I take this objection very seriously, but if a principled path is available, if it isn't doomed to failure at the outset, then I think it should be pursued rather than abandoned without a fight. I also wonder whether the special tribunal in its various forms will face similar opposition by permanent members wary of setting a precedent that could be used against them in the future. The more interesting objection, which Carrie also alluded to, is legal. It's a bit complicated, but I think it boils down to four claims. So the first claim is that the ICC has only that jurisdiction that is given to it. Second, states have no universal jurisdiction over the crime of aggression, excuse me, committed outside of their territory and not involving their nationals. and so cannot give such universal jurisdiction over the crime of aggression to the ICC. Third, the Security Council can give the ICC jurisdiction over the crime of aggression wherever it occurs. And fourth, the General Assembly cannot. The General Assembly can recommend action and reaffirm existing legal rights and obligations, but it cannot create or change legal rights or obligations of states or of international organizations. I find this objection very interesting, but ultimately unconvincing. Some of my reasons are somewhat theoretical, so let me try to put them in a practical register. So how would this objection play out in practice? So suppose that the proposed amendment is adopted, ratified, the General Assembly refers a situation, perhaps that in Ukraine, and a defendant appears before the court and raises this objection. The defendant would essentially be asking the court to ignore the amended text of the Rome Statute and decline to exercise jurisdiction over the crime and the defendant based on considerations of general international law. How would the court respond? So first, if the victim state, the state against whom aggression has been committed, in this case Ukraine, accepts the court's jurisdiction, then the court will dismiss the objection as beside the point, even on the delegation theory. The court would not be exercising universal jurisdiction delegated to it by states parties or by the General Assembly, but rather the territorial jurisdiction delegated to it by the victim state. Now, what if the victim state does not accept the court's jurisdiction? It's hard to imagine why it wouldn't, but let's just go along for the sake of argument. Then the court will say, interesting objection, but 2/3 of states parties, 82 states, adopted the amendment. 7/8, 108 states ratified or accepted it, and 2/3 of the General Assembly, at least 129 states, endorsed it when they referred the situation to the court. And in so doing, they, the states, decisively rejected your objection, and so does the court. In other words, if it is uncertain whether states enjoy universal jurisdiction over the crime of aggression, which they may be reluctant to exercise themselves, but are free to delegate to the court, then there is a way to resolve that uncertainty, and that is to initiate the amendment process. If that process succeeds, we will not only lay any legal doubts to rest, we will have a principled, pragmatic, permanent mechanism for confronting aggression by the world's most powerful and least principled leaders, starting with Russian President Vladimir Putin. Thanks.
Thank you very much, Professor Hack. And we will now turn to the Q&A session, and there are already plenty of questions. I will start with the first question addressed both to Dr. McDougall and Professor Heller concerning the engagement of either EU or the Council of Europe in the special accountability mechanism for Ukraine. So essentially the question is, would not the message...
So I personally would advocate for the broadest international model that we can realistically achieve. And so I think it does depend on whether we go down an agreement route or a treaty route. A treaty could be open to all states, and I think you would be able to pull together a cross-regional group of states representing all 5 UN regions, and to me in many ways that would be optimal to keep it at the tribunal as international as possible, as I indicated, for reasons of legitimacy, but also because it relates to the immunity issue. I think there's probably a mechanism, even if you ended up with an agreement between the European Union and Ukraine, that you could create a mechanism whereby other states could cooperate on a voluntary basis, provide funding or means of support. So you could also, even if it ended up being an exclusively European mechanism, there would be ways for other states to signal their support.
Thank you, Professor Heller.
Thank you. At the normative level, of course, I support as broad of international support for any kind of tribunal that is created as possible, which is why I said that it is certainly seductive to go the General Assembly route. And there my concerns are the pragmatic ones that Carrie articulated really, really well. I do think, however, that the selectivity issue is an extremely important one. If there was genuine international agreement across the board, well, of course, the broader the better. In the absence of that, I think there is a very, very serious problem with a tribunal being dominated by some of the same states that have not shown as much of respect for the crime of aggression as others. It is impossible to look at the creation of the ICTY, the ICTR, the Special Court for Sierra Leone, and not think that the same states that have traditionally dominated international criminal law will continue to. So I think the way to essentially insulate a court from that kind of delegitimizing selectivity or delegitimizing dominance is to focus on the European region. Whether it's the EU or the Council of Europe, I mean, I'm somewhat agnostic on the specific organization. I do think there are reasons that I articulated for the Council of Europe, but they're the ones who I think have the most credibility to deal with Russian aggression. And kind of like Carrie said, I would be fully in favor of some mechanism where other states could kind of sign on and exhibit their support for a Ukraine-based hybrid tribunal. I mean, that's what states did after World War II in terms of endorsing the London Charter, but I'm concerned about the operational level. And there, I think there is a reason that European states, and also, as Carrie said, particularly the states that are in Eastern Europe, should play the lead role in working with Ukraine to develop this kind of court that we've been advocating.
Thank you very much, Professor Heller. And we have quite a few questions concerning Nuremberg and the legacy of Nuremberg and the messages from Nuremberg. And I would like to address these questions to Professor Gnatowski, because so far the commentaries that we have seen don't really take into account the regional idealization of Nuremberg in Eastern Europe, and especially in Ukraine and in Russia. So Professor Gnatowski, how do you think that might impact the Nuremberg-like model of a potential tribunal? How does it might it impact the perception of the tribunal, the embrace of its judgments and legacy in Ukraine, and more importantly in Russia?
Thank you very much for this question, and also thanks to the participants of the webinar who have inquired about Nuremberg. Nuremberg is certainly an analogy that has to be looked into. Also, not the least because the Chatham House Declaration of the 4th of March alludes to London, to St. James Declaration of 1942. I tend to think that this is among the models that have been so far discussed, that remains the most convincing to me, in as much as we could repeat Nuremberg's experience in having a group of states setting up a multinational tribunal, being open for other states to either join the relevant treaty, the relevant agreement, or to express their support to this tribunal without even joining it, but just by means of a political declaration or a statement from their foreign ministries or from their heads of state. So I genuinely can't see why that is not an option. I mean, I'm just as selectivity could also be invoked as a criticism for the Nuremberg trial. I think no one would seriously argue that its selectivity was a reason not to prosecute the Nazi leadership. And so for me, the possible selectivity criticism and invoking whatever arguments that, whatever other violations or alleged violations of Article 2, Paragraph 4 of the UN Charter might have happened since 1945 and were not prosecuted in any court of law, that would not essentially be detrimental to the idea that, like in Nuremberg, Putin and his cronies have to face criminal prosecution for the crime of aggression of a scale which, let me once again repeat, is unprecedented in Europe since the end of the Second World War, and also the one that has received already such a clear assessment from the UN General Assembly with the overwhelming number of states in support. And I understand that it is instinctively an interesting idea to involve European organizations. such as the European Union or the Council of Europe, with which I have very closely worked for the last 12 years. And I have a lot of admiration for this organization, which is now cleansing itself, since the expulsion of the Russian Federation from various compromises that it had to strike with its own core foundational values, just trying to remain a place for dialogue. But I'm digressing. So now back to the Nuremberg, to the glorification of the Nuremberg trial. I think it's also interesting to invoke the Nuremberg model, precisely because, as Dr. Bussel has just mentioned in her question, this tribunal has to be attached particular importance, not just in Eastern Europe. Let's call spade a spade in Russia, because part of the historical revisionism that is now even criminally, potentially can lead to criminal responsibility in Russia, punishable in Russia, is questioning some of the statements made in the Nuremberg judgment, statements of fact, which then proved to be factually incorrect, even though they didn't change the main conclusions of the tribunal. So that's why I think Nuremberg is perfectly a legitimate model. There's one more reason why Nuremberg could be invoked. The Nuremberg Tribunal, the International Military Tribunal, was actually the end of the era. This marked the end of the era of the international law prior to the UN Charter. And actually, its creation essentially coincided with the creation of the current collective security architecture in the United Nations, based on the Security Council and the crucial role of the P5 in the Security Council. And as now we see, I mean, this has been discussed for decades, that this architecture is inefficient when at least one of the Security Council permanent members is involved in a conflict. So now we can see a plain abuse of the right of veto by one of the permanent members. And this basically brings us back, this throws us back to 1945. So perhaps restarting this with a new Nuremberg or a new multinational tribunal could also merit serious consideration. Thank you very much for this question.
Thank you very much, Professor Gnatowski. And now over to Professor Huck. We'll have a question about the impact on a potential peace agreement on any form of accountability of Russia. So what's your opinion, how any demands of Russia concerning the lack of investigations and prosecutions in a potential peace agreement might impact the accountability and the potential ICC referrals which you proposed?
So I think it really will depend on Ukraine. So many of the models that we've been discussing require Ukraine's active participation. So if Ukraine did not cease to consent to the ICC's jurisdiction, if they did not support whatever hybrid model was proposed, that would create a serious problem going forward with accountability. So even though the prohibition of aggression is a peremptory norm, it violates obligations owed to all states, it may be a crime triggering universal jurisdiction. Even so, without Ukraine's active participation, it would be very difficult. So if Russia were able to extort that kind of concession from Ukraine, that would create a very significant obstacle on many of the models that we've been discussing. And I can't really speak to whether Ukraine would be willing to give that concession. So I'll just leave it there.
Thank you very much, Professor Huck. Professor Heller, there is a question about the temporality of the crime of aggression that we are looking at. Any potential tribunal, in your opinion, should it look into the events which started on the 24th of February 2022, or shall we actually speak about the events which have been unfolding since 2014?
I think it's an excellent question. I'm guessing Carrie's going to want to weigh in on it too. I think the easy legal answer is that it's not really a legal decision. I don't think there's any issue with retroactivity going back to 2014. Now, there is a larger issue about what the definition of aggression is under customary international law, and we don't have time to replay all the details today, but it's an important one. Is the crime of aggression post-Nuremberg really based on the Nuremberg precedent, or is it closer to the more expansive definition that we see in the Rome Statute? I think the good news is that we don't have to reach that decision. We probably don't have to reach that decision even if we would go back to the events of 2014, because if nothing else, Nuremberg stands for the categorical criminality of an invasion that leads to annexation. Conquest is at the heart of the Nuremberg paradigm, and that is the paradigm that Russia has been repeating with such devastating effect. So I think it's more of a political decision about how you want to create a tribunal than it is a legal one.
Thank you very much. And we have the question about the interplay of the different justice initiatives, which we're seeing concerning the different aspects of Russia's conduct in Ukraine. The member of the audience basically invokes the proceedings before the International Court of Justice and asks how that might interplay with the accountability mechanism for the crime of aggression. Dr. McDougall, would you be able to take this question? Thank you.
Yeah, of course, Katerina, thank you. It's a little bit difficult to see how the proceedings in the International Court of Justice might unfold. The ICJ has, of course, issued preliminary measures ordering Russia to cease military operations and to cease supporting other armed groups that are carrying out hostilities on Ukrainian territory. But we're yet to get to the merits stage of the proceeding. And of course, in some ways, because of jurisdictional issues and the like, this is a use of force question that's been shoehorned into the Genocide Convention. So my own view is that Ukraine's lawyers have put forward an absolutely brilliant argument. I think there's a good prospect that the court will find that it has jurisdiction to hear a dispute arising under the Genocide Convention, and that the pretense, or absolutely imaginary claims that Ukraine was committing genocide in Donbass will be found to be false and an impermissible basis for Russia's quote unquote special military operation. But I myself would be surprised if the International Court of Justice can say very much more about the use of force, other than perhaps expressing concern, as the court did at the preliminary measures stage. So I think, in some ways that the two proceedings that we're talking about would complement each other very much, but I don't think there's any risk of a conflict or overlap of jurisdiction. Because on the one hand, we're talking about issues of state responsibility, and what we're primarily focused on here today is criminal accountability of individuals.
Thank you very much. Professor Huck, may I address to you a number of questions we have concerning the immunities, and particularly how they might impede the prosecutions of specific high-level individuals for the crime of aggression before the ICC and before any potential tribunal.
In the case of the International Criminal Court, of course, the appeals chamber has already ruled on this issue and said that not only are immunities not applicable against the court itself, they're also not applicable against states executing arrest warrants issued by the court. So for the ICC, we know what that legal framework is going to look like. And I'll note that, again, if the proposal that Shane and I have sketched were adopted and triggered, this would be kind of further definitive evidence that that framework is acceptable to the vast majority of states. As for the other proposals, I think it really depends on the details. I think one virtue of the ad hoc model that depends on a vote of the General Assembly and a treaty between the UN and Ukraine is that I think it has the strongest claim to a similar type of argument, that this is a robustly international court. And so the concerns that motivate immunity at the horizontal level do not apply in this vertical context. As for the other models that Kevin and Carrie have sketched out, I'll leave it to them to discuss how immunities might or might not apply there.
Thank you very much, Professor Huck. Kevin, Kerry, would you want to make any comments concerning the immunities within your proposed models?
Sure. I mean, it's an important issue, so I'm happy to make a few additional comments. I mean, I think we need to acknowledge that the law on immunities is very complex and in something of a state of flux. Maybe to give a little bit of background for those less familiar with this area of the law, the International Court of Justice in the arrest warrants case held that heads of state, diplomatic representatives, ministers of foreign affairs, by implication heads of government, enjoy immunity from criminal proceedings in foreign domestic jurisdictions during their term of office for all official and private acts, including serious international crimes. Relevantly, though, the majority held that once leaving office, such persons can be prosecuted for acts committed in a private capacity during their term in office. And some people argue that should, a crime against humanity, a war crime, should never be regarded as an official act. But I think it's very difficult to extend that argument to the crime of aggression, given that we're by definition talking about a use of force that's been authorized by states. And so it has alternatively been argued that there's a customary law exception to functional immunity for serious international crimes, regardless of whether they're committed in a private or an official capacity. And that view is certainly reflected in the International Law Commission's provisional conclusions on the immunity of state officials from foreign criminal jurisdiction. But really importantly, aggression is not included in the list of crimes contemplated by the ILC. And so I think, it's very difficult to make a convincing argument that a foreign court could exercise jurisdiction over someone who enjoys immunity, which is, one of the reasons I think an international court is needed. Now, in the arrest warrants case, the ICJ held that someone who enjoys immunity may be subject to criminal proceedings before certain international criminal courts where they have jurisdiction. And we've just got this snippet in the judgment to go by. And of course, the million-dollar question is, well, what is such a court? And that's where I think, and maybe this is where Kevin and I mostly disagree. This is why I think we need a court that is not part of Ukraine's legal system, but rather is an international court to try and make sure that we fit within this, phrase from the arrest warrants case. Because I think assuming we can secure support for a genuinely international tribunal, there is a strong argument that immunity wouldn't apply. So the Special Court for Sierra Leone has held that Charles Taylor couldn't claim immunity before it. As Adil mentioned, the ICC has held that states parties couldn't rely on any immunity enjoyed by President al-Bashir of Sudan, as he then was, to avoid their obligations to execute arrest warrants issued against him. And, these decisions have been widely criticised, but at some point, those critics might have to accept that their arguments have been made and rejected several times by duly constituted courts of law, such that it's, I think, very difficult to see an ad hoc tribunal reaching a different conclusion.
Thank you very much. Professor Heller, do you want to make any comments concerning the immunities for your proposed model?
Sure, just briefly, less so about my model than in general, that again, I agree with Carrie that we don't really know what the ICJ means by an international tribunal. I would simply add that I don't think the hybrid label is a legal one as opposed to an empirical one. I mean, under hybrid is the Cambodia Tribunal, the Special Tribunal for Lebanon. I mean, the hybrid really just describes the role of the international. And there was a question I saw in the list about why not go completely domestic and just have this be a domestic Ukraine prosecution with expertise lent to it by other states. And there, I think the presence of hybridity is really important. I think you do need the international aspect of a hybrid tribunal to have any credible argument that immunity could be overcome. And as long as you have that presence, I don't see the difference between the General Assembly endorsing a tribunal and the Council of Europe helping Ukraine Ukraine create a tribunal to which many other states lend their endorsement. If one works, I think the other works just as well.
Now we turn to Professor Ignatowski with two questions which concern not just law, but policy and politics in Ukraine. So first question is about, with such a huge international attention to Ukraine and Ukraine's apparent willingness to see more accountability for alleged war crimes, crimes against humanity, and the crime of aggression, do you see any prospect of Ukraine's ratification of the Rome Statute, which has been not happening for so long? And also, the member of the audience asks, why doesn't Ukraine basically proceed with proclaiming this tribunal already and then basically requesting the support from Western nations and international organizations to support this tribunal financially further?
Yes, thank you very much for these questions. As regards the Rome Statute, first of all, let me once again remind everyone that Ukraine has consented to the jurisdiction of the International Criminal Court. So since 2015, the court is competent to look into any war crimes and crimes against humanity committed in the territory of Ukraine since the beginning of Russia's aggression, i.e. since 2014. There was an obstacle to the ratification of the Rome Statute. That was an opinion dating back to 2001 from the Constitutional Court of Ukraine. And as Ukraine was, it had been an extremely peaceful country, never thinking of any prospect of actually matters of international humanitarian law, international criminal law being directly relevant to it. Therefore, the addressing the problem created by this opinion of the Constitutional Court had been very slow. Well, I for one was one of those pushing to address it, but of course, everyone thought that I'm doing this purely of theoretical interest. So eventually in 2016, Ukraine passed an amendment to the constitution to Article 124 in particular, which included basically French model saying that Ukraine can ratify the Rome Statute no matter what conflicts might have been found by the Constitutional Court, and that amendment entered into force in 2019. And now it's still very slow, but it's in the pipeline. I assume the full ratification will come. But again, for all practical purposes, the ICC doesn't really need this. It's the Ukraine who needs to ratify the Rome Statute and not the ICC to do anything in Ukraine. It's a severe situation because it's inexplicable why after giving full consent to the jurisdiction of the ICC, one doesn't ratify the statute. It's now as regards the question of why not proclaim it now, it's precisely because we are looking for a model which would lend it the biggest possible support. And again, I don't want to reject any of the options. Let me just say that any efforts that are already being done domestically to investigate this crime, I think they will not be wasted. I think they're perfectly relevant. Ukrainian courts are perfectly capable of dealing with this crime now. So it's not a question that Ukraine needs particular international support to do exactly that, because one might need more support to properly document and investigate war crimes and crimes against humanity, where proving all the causal links and all that stuff is fairly complicated, but not, or at least cumbersome and lengthy, but not the crime of aggression, where, quoting Philip Sands, the indictment is actually writing itself. So and by the way, this is the response to the argument that this would be a costly exercise and so on. It will not be a costly exercise for sure. This doesn't require a big office. This doesn't require many judges. That doesn't require a lengthy procedure. This could be completed in a matter of months, at least at the indictment stage. And then one can talk about in absentia or not in absentia. I, for one, is not convinced that in absentia should be ruled out completely. But again, that's another topic for discussion in this particular case, though. So certainly for Ukraine, any option is good as long as it gathers enough international support. And let me say one additional thing here on this occasion, that I don't think that this is a purely Ukrainian or a purely regional matter. the attack, the very basic foundational principles of international law have been attacked. And this is a matter for everyone. And the pretext for the attack is a completely imperialist approach and imperialist rhetoric. So this should ring a bell also with African states, for example, and states in other regions. But certainly that needs additional work and additional explanations. So I don't think that this is something that is purely regional. However, regional approach is also good. I mean, I'm all in favor of the involvement of the European Union and/or the Council of Europe, provided that other states also endorse this. Because my final point about immunities, if I may, I fully agree with all the analysis provided by Professor Heller and by Dr. McDougall, but I fully agree again. But here, I mean, let the state concerned challenge this. You know, let me remind you that the Russian Federation is a state which has never ever submitted itself to the jurisdiction of the International Court of Justice voluntarily. It has withdrawn its signature under the Rome Statute. It has been expelled from the Council of Europe, and this expulsion was also accompanied by Russia's statement that they want to leave anyway themselves. So you know, this is a state which is at the current stage is completely ignoring international law and offering nothing but contempt to all these clever discussions about subtleties of international law. So I think one doesn't have to be so afraid to push the limits a little bit. Again, coming back to the Nuremberg trial, we know today all the problematic issues around its creation, and there are plenty. And believe me, there will be much less such issues around any possible arrangement for the crime of aggression against Ukraine. This would eventually contribute to solving global problems, but let's not try to solve global problems now and then find out that we can't solve them. And basically, in the meantime, nothing has been done for this particular case. Thank you very much.
Professor Ignatowski, and you mentioned the in absentia trials, and we have a question concerning that as well. There has been just a bit of an intro. Ukraine before this February 22 has actually worked not just on accountability, but on reparations and a possible truth mechanism. And a lot of criticism was there that over focusing on accountability, we don't help individual survivors. We don't provide medical, psychological support. We don't provide housing. Many international experts who, of course, supported this position, they provided the example of the Special Tribunal for Sierra Leone, saying that costly international proceedings usually outweigh the amount of support that is given to the ordinary survivors who need that the most. The question here in the chat is actually exactly about that. Why do we need to support any accountability mechanism, be that the one at the ICC or a special tribunal, if the states further might not necessarily for the business or other reasons try to enforce the implementations of those possible decisions on Russia, sanction Russia, and see the actual effect on the ground and help the survivors? Professor Haq, could you comment on that, please?
I guess what I'd say is just that when we think about why aggression is a crime, it's partly to protect certain state interests and collective interests of a population. It also serves another function. If we only punished war crimes, that would leave a lot of violence unaddressed. So violence inflicted on Ukrainian soldiers who, after all, have done nothing other than try to defend their country, as well as harm inflicted on Ukrainian civilians that for one reason or another doesn't violate international humanitarian law. So the crime of aggression partly addresses those harms that war crimes leave unaddressed. By the same token, reparations or compensation for aggression encompasses all the injuries inflicted by the aggressor state. And this was just recently reaffirmed by the International Court of Justice in their reparations judgment on DRC versus Uganda. So reaffirming this idea that all the harm inflicted in furtherance of a war of aggression is incurs state responsibility and obligations of compensation. So how that compensation is paid and how it's distributed to individual victims, I think is a further question, but I think it is important to reaffirm that point of principle, which is how the ICJ framed it, as a matter of principle.
Thank you very much, Professor Huck. And we've got an interesting comment and question concerning potential universal jurisdiction proceedings and whether the protective jurisdiction could be used in this case, especially if states are affected by the influx of war migrants. And I would just remind that there are more than 4 million of Ukrainian refugees, and the number is still growing, and the whole amount of displaced persons has already reached 10 million. Professor Heller, would you comment on this, please?
Sure. I mean, I think the protective jurisdiction, universal jurisdiction debate is actually something of a red herring here. Unless we're planning on sidelining Ukraine, any of the models that we were talking about will be built on the territorial jurisdiction of Ukraine. I know that the statement and declaration were drafted quite quickly, but where it references pooling of jurisdiction, it's just not necessary. The whole point is that this was a crime committed on the territory of Ukraine, that Ukraine can, in any of the formats that we are talking about, join with other states to address. So for individual prosecutions, and I do think it's important to emphasize that I don't think anybody in this panel thinks it has to be one of these models and nothing else. I think we would all look for a multi-layered system that involves domestic prosecutions with states that have it, with an international tribunal, a hybrid tribunal, the ICC pursuing war crimes and crimes against humanity. We all want to see it as an interlocked system. So I do think the protective jurisdiction argument might be interesting for a state that is considering initiating its own domestic investigation of Russian aggression. And there, I think it probably works. But I still think the most fundamental point is that it is Ukraine's territorial jurisdiction that it is free to do what it wants with in terms of addressing Russian aggression.
Thank you very much, Professor Heller. And we've got a question to Professor McDougall in terms of the complexities of prosecuting aggression and the type of evidence needed for that. Could you comment a little bit on that and how that evidence might be similar to the evidence gathered concerning the alleged war crimes and crimes against humanity?
Okay, so I mean, the evidence bases are really quite different. If we look, at the precedent from Nuremberg and Tokyo, for example, we see that both tribunals were very much focused on all of the events leading up to the initiation of hostilities. And that is really where the key decisions are made by leaders about using force against another state. So a lot of the evidence is going to be readily available on the public record. I agree with Professor Natovsky's comments about the fact that, the crime of aggression, at least with such a clear-cut case, doesn't involve the same sort of painstaking investigations that you might need to put together to prove, broad war crimes, crimes against humanity, and particularly when you want to try and tie crimes committed in the field to puppet masters. So very different, both evidence base for the different crimes. One, you're talking about decisions to unlawfully use force against another state. In other examples, we're talking about violations of humanitarian or human rights law. But also, I think, a much clearer path from investigation to prosecution.
Thank you very much. And we've got the next question to probably Professor Heller and Professor Huck, if you don't mind. So as regards the involvement of any Western powers, how would you comment on the assistance of the Western powers like the UK and the US, who are now helping Ukraine to develop domestic proceedings, but then of course are quite reluctant or sometimes slow in addressing the alleged international crimes perpetrated by their nationals?
Who first? Adel?
Sure. So I guess I'll just say that the charges of hypocrisy, they write themselves, and this is actually not the most serious example. Helping another state develop its legal capacity to deal with a very, very extreme situation. As hypocrisy and inconsistency goes, this is a minor case. Look, the optics are going to be terrible. As Kevin mentioned, what is very much at stake in the discussion of aggression is not only the unlawful use of force, but the attempt to acquire territory through the unlawful use of force. And sure enough, last week, the Secretary of State of the United States decided to visit Morocco and Israel on his tour, two states that are precisely seeking to acquire territory through force. So the charges of hypocrisy, they write themselves. I don't really see much of a way around it. In general, I would like to see the US and the UK kind of lead from behind, provide resources, provide political support in the background, but not try to be at the head of the charge, waving the flag of justice. I think they should leave it to other states to take that more symbolic role.
Yeah, I'd like to, well, first, second what Adil said it better than I possibly could. And so let me just kind of touch briefly on a different angle, which is, I ended my presentation by saying that we obviously first and foremost have to be concerned about the Ukraine situation, but that we also have to be concerned about the long-term viability of the crime of aggression. And I think this is a really good example. I'm often get the response, well, isn't some justice better than nothing? Don't we have to start somewhere? Wouldn't this be a precedent for future tribunals? And I have to admit my cynicism there. I think part of the answer is one of the reasons why many powerful Western states are willing to endorse a tribunal just for Russia is that it is a tribunal just for Russia, and that would not be setting a precedent for them in terms of addressing their own potential crimes. But beyond that, I think we need to take seriously forgive the organizational management language, but the startup costs of an ad hoc tribunal. The possibility of replicating the kind of tribunal that would be patterned on the ICTY is so overwhelming that it makes it so unlikely ever to be repeated, except in perhaps, again, the most egregious situation. The kind of tribunal that we're advocating, a hybrid model that is built on the court system that already exists in a country, that could be replicated far more effectively, far more efficiently, and far more quickly than a full-scale ICTY-like tribunal. And so if you're thinking about going forward and dealing with other situations involving aggression, we think it's a better model. We also think there's more deterrent value for precisely that reason, that the likelihood of an act of aggression leading to a full-scale ICTY-like ad hoc is pretty slim. The likelihood that we can develop a model where states can use their own domestic courts with the assistance of the international community to deal with aggression, that's much more likely. And so I think a would-be aggressor would be much more likely to fear a successful hybrid aggression model than it would be even a successful ad hoc one.
Thank you very much,
I think
Professor
Barry
Howard.
wanted to add in.
Thank you. Dr. McDougall, you wanted to add, please.
Thanks, Katerina. I would like to just add a comment because, I think this concern about selectivity and cost is one that I've received a lot of comments on. And in terms of selectivity, I think the first point to make is that, this is arguably the first, or at least the clearest cut case of a crime of aggression since the adoption of an internationally agreed definition of the crime of aggression in 2010. So I'm not actually convinced that the proposed tribunal would represent a particularly unique example of selectivity, which is a problem for international criminal justice more generally. In terms of hypocrisy, I've seen firsthand the strength of the UK, US, and French opposition to the exercise of the ICC's jurisdiction over aggression. And I would personally be very surprised if they became prime movers in the establishment of an ad hoc tribunal to prosecute the crime of aggression committed against Ukraine. But I acknowledge that even if the initiative is led by other states, that wouldn't eliminate selectivity concerns. And I would agree that those concerns are real. Of course, victims in places like Syria and Yemen deserve justice as much as the victims of this crime of aggression. But I guess unlike Kevin, I really don't see the advantage of standing on principle and letting perfect be the enemy of good. If we refuse to support justice initiatives when they're available, unless justice everywhere is possible, we will effectively have to give up on the international criminal justice project. And, in my mind, that's not going to help victims in Yemen or Syria. It's just going to send a message that serious international crimes can be committed with impunity by powerful men with massive egos who want to shape the international order to their liking, which will only lead to further aggression and the commission of more international crimes. And so my view is that we can support an ad hoc tribunal for Ukraine while also acknowledging that justice is selective and that is unacceptable. And I think, in realpolitik terms, the best chance we have of making justice less selective is in fact by demonstrating that international criminal courts can apply justice impartially, independently, and fairly, and that they're an indispensable part of the international security architecture.
Thank you very much, Dr. Maglu. Professor Heller, you've got a response.
Yes, just very briefly. I think it's important to emphasize that no one on this panel doesn't want an accountability mechanism for Russian aggression. It's not a choice between the ICTY model and nothing. If it was, I would be in favor of the ICTY model for all of the reasons that Carrie just ably articulated. The point that I'm trying to make, and my co-collaborators have been trying to make, is that's not the only model possible. There are other models that will work just as well, and for the reasons that I've tried to articulate, might even work better than a full-scale ICTY like ad hoc tribunal, both now and going forward for the crime of aggression.
Thank you very much. And as we are gradually winding up, I would like to address two final questions to Professor Gnatowski, because they also concern not just the legal issues, but Ukraine's vision of those issues. So the first question is, how does Ukraine, if at all, react at the cyber attacks? Because we've been speaking largely about the crime of aggression and war crimes, but what effort and how connected it could be in Ukraine's reaction towards the warfare in the cyberspace. And second, eventually, when we speak about the outcome of all these trials, what we would want to have are reparations for survivors and something quite huge in amount to rebuild Ukraine. So what avenues do you see in ensuring this resources for rebuilding Ukraine? Ukraine has spoken largely about the assets freezing of Russia abroad, how that can be implemented. Professor Gnatowski, over to you.
Thank you very much, Katerina, and thanks for these questions. Of course, they are slightly beyond the topic of our today's exercise, but therefore I will be very brief. As regards cyber warfare, well, what does Ukraine do? Ukraine defends and Ukraine counterattacks. As regards, and of course, when those attacks committed against Ukraine amount to war crimes, then they have to be investigated as war crimes. Now, as regards, or crimes against humanity for that matter, hopefully not. And as regards the reparations, I'll try to connect this to today's topic. I think that the fact of criminal conviction of the authors of this aggressive war, and potentially some of the sponsors of this war, as well as some propaganda people, I would tend to think that this should also be given serious consideration. That might actually be strengthening the efforts to secure some of the reparations, at least when it comes to their to personal assets. But in general, indeed, account freezing of accounts is good. But then the question is, what do you do with this? And there's several options. Of course, you can just take this money and send it to Ukraine, which is as part of international responsibility. But that would be a rather straightforward and rather difficult step. There's another one which is also problematic. You allow basically lawsuits in your domestic courts, and you waive jurisdictional immunities, which is also not so easy, but perhaps in the mode of international responsibility for a violation of an erga omnes obligation, why not? And finally, some kind of a claims tribunal along the lines of US-Iran claims tribunal could also be considered at some stage if this assets frozen and this no other way for Russia to get hold of them. So there's options, of course, but I think the project on the criminal responsibility for the crime of aggression is something that is seriously potentially strengthening international rule of law, and that's why I think it's very important that we discuss all these options today. And as this might be my last opportunity to take the floor, I would like to thank my co-panelists for their brilliant insights, and also to you, Katerina, for your wonderful moderation. Thank you very much.
Thank you very much, Professor Gnatowski, and we are all hoping that these discussions are useful for the policymakers, both Ukrainian and Ukraine's foreign partners. And it's very important to stress, as Professor Heller has mentioned, that everybody here supports the accountability of the Russian Federation for this horrendous crime. So just that the modalities which we are trying to figure out. And I think it's also important to stress that all of us agree that the interests of the survivors should be at that core of that mechanism, and hopefully also the mechanism that will eventually be there will of course be embraced by history later, and especially by the people in the region and also the Russian population, because it's also something for them to accept as part of their legacy. Dear colleagues, I'm very grateful to you for this very insightful discussion. I'm very grateful to all the members of the audience for their attention and for their questions. I would just ask the members of the audience to respond to a quick, to provide a quick feedback about this event so that we could make them better further. You will receive a notification here after Zoom and a feedback request after on your emails afterwards. Thank you very much for your attention to this webinar. We are hoping to have further events on alleged war crimes and crimes against humanity perpetrated in the context of Russia's aggression. Meanwhile, please stay safe and see you soon. Thank you very much.